Rob Hennig.
43. All right, we're on file item 43 by Assemblymember DeBobne, which is AB 2693.
Madam Chair, colleagues, today I'll be presenting 2693, the Pace Preservation and Consumer Protection Act. I am accepting the amendments laid out in the mock-up provided to you. These amendments address concerns raised by stakeholders. I understand a few additional concerns may remain, which I hope to address as the measure moves forward, but I believe that this bill, as it stands, is a tremendous success of compromise that will allow consumers to be better protected in our state. AB 2693 is a bill that positively impacts the PACE program by implementing much-needed consumer protections. AB 2693 establishes a uniform disclosure that must be provided to each homeowner prior to participating in the PACE program. The disclosure will ask providers to notify homeowners of the product's costs, financing costs, as well as other associated costs that go along with taking part in the program. Additionally, the measure requires a 3-day right of recession to allow homeowners an opportunity to cancel without any penalties if they change their mind. I have heard countless stories from homeowners who took out a PACE loan and were unaware it adds a lien to their property, or unaware that they would not be able to sell or refinance their house without first paying off the entirety of a PACE loan. This is incredibly troubling, considering for most Californians, their home is their biggest investment. I fully support the program and its goals of reducing our state's carbon footprint. This is a necessary, what I believe, endeavor, considering the number of environmental laws we've passed over the last few years that lead the way for a better and greener future. It is undeniable that the PACE program has allowed thousands of Californians to purchase energy-efficient upgrades that they would not otherwise have been able to afford. However, the only way to ensure that this program continues and is available to a big marketplace is that it is sustainable. And to be sustainable, we must make sure we have strong consumer protections. So I ask for your aye vote today. But with me today, I have Congressman Brad Sherman from the San Fernando Valley, Stan Wigg from the California Association of Realtors, and Courtney Jensen from the California-Nevada League of Credit Unions. Congressman Sherman.
Very much. Witnesses, Congressman.
It is such a pleasure to testify before your committee twice in the same day. For 20 years, I've served on the Financial Services Committee in the United States Congress, where it is so important to allow people to buy, sell, and refinance their homes. The federal government has established Fannie, Freddie, and FHA, and it is simply amazing that we have a home finance system that allows ordinary people to borrow hundreds of thousands of dollars at rates lower than those currently being charged the British government. We should not take this system for granted. We need to make sure that those who are encumbering their homes get clear information. At the same time, as an environmentalist, this is an important program that allows people to reduce or even eliminate the carbon footprint of their home. That's why we do need a bill that provides for clear disclosure. This is particularly important because many of these PACE loans have prepayment penalties. So if you pay earlier, you're paying more. And in fact, this prepayment penalty provision is triggered not because you choose to prepay, but because you choose to sell or even refinance your home. The FHA will not allow a refinancing if this super lien is on the property, so it has to be prepaid. And so if there's going to be a prepayment penalty, that ought to be disclosed, and I think the program will work better with that clear disclosure.
Thank you. Other witnesses in support?
Madam Chair, I'm Stan Wigg with the California Association of Realtors. We are co-sponsors on the bill. This bill treats property assessed clean energy loans like any other loan. It requires substantial compliance to the same kind of truth in lending that we have on any other loan. It is substantial compliance, so there's flexibility for the various players to modify per their marketing and their structure, but it also establishes a statutory form so that we are tracking what you would see in any other kind of consumer loan. Similarly, as the Assemblyman mentioned, the rights of rescission are like a home improvement contract, like any other loan would be, and we ask for your aye vote.
Thank you very much.
Madam Chair and members, Courtney Jensen with the California Credit Union League. I can't say it better than the previous speakers, but we want to thank the author for his really hard work on this issue all year long. This consumer disclosure is very important for our credit union members, for them to understand what they're getting into when they do these PACE loans. The number one thing we're hearing is they don't understand the implications of the super priority lien that they're putting on their property. And so with that clear consumer disclosure, we think that that will be very helpful, and we respectfully request an aye vote.
Thank you very much. Other witnesses in support? Are there any other witnesses in support? If you'd step forward to the microphone, name, affiliation, and indication of support.
Madam Chair, committee members, my name is Craig Page of the California Land Title Association. The title insurance industry strongly supports this bill.
Thank you.
Madam Chair and members, Lexi Howard with California Advocates on behalf of the California Mortgage Association, California Escrow Association, and United Trustees Association.
Thank you.
Janine Wittishausen, Placer County Treasurer Tax Collector, and also on behalf of the Placer County Board of Supervisors. We are moving from a oppose unless amended to remove all lien subordination language, so we now strongly support the bill.
Excellent. Thank you.
Good afternoon, Madam Chair. Karen Lang on behalf of the California Association of County Treasurers and Tax Collectors, who have had a lot of interesting phone calls so far, in strong support of this bill, hoping to cure that problem. Thank you.
Thank you.
Jason Lane, California Bankers Association, in strong support. We'd like to thank the author for his efforts.
Very good. Thank you very much. Any other witnesses in support?
Amy Jenkins with Platinum Advisors on behalf of Y Green Energy Fund. We have a supportive amended position on the bill. We applaud the author and the staff and the sponsors for all their work thus far. We do have one additional issue in particular that we need to address, but we're working with the author and the sponsors.
Very good. Thank you very much. Other witnesses in support?
Hello, Madam Chair, members. Jason Ryan, League California Cities, and also on behalf of the California State Association of Counties. We're not in support, but we're not opposed. And we've been working very hard with the author.
So you're one of those in strong neutrality.
Well, not exactly. We do have some remaining concerns. They're technical in nature, however, they are all meaningful. We would like those addressed. The author has shown good faith and has continued to work with us. We're meeting with him, in fact, next week. We're hoping that we can actually get those ironed out before it hits the floor. And with that, we're hoping to get to support.
Very good. Thank you. Any witnesses in opposition? Witnesses in opposition? Good afternoon.
Thank you, Madam Chair. My name is Jewel James. I'm the Vice President of Market Expansion and Policy at Renovate America. Renovate America is headquartered in San Diego, and our PACE platform, which is called HERO, is offered in partnership with the Western Riverside Council of Governments, the San Bernardino Associated Governments, and LA County. We appreciate Assemblyman DeBobney's leadership and also Congressman Sherman's testimony here today regarding the importance of consumer disclosures. We also appreciate the longstanding support of the California congressional delegation as recently expressed by Congressman Sherman and 29 of his Democratic colleagues, and a letter to the Department of Housing and Urban Development that you have before you, where the delegation said PACE programs, because of their partnership with local and regional government, include consumer protections not found in conventional financing options. Homeowners have greater assurances through PACE about the quality and fair price of the product they are purchasing, the caliber of the workmanship, and the long-term support available to them throughout the useful life of their purchase. Renovate America wholeheartedly supports the author's goal of ensuring that consumers who enter into PACE financing agreements fully understand the financing terms, and we're actually dismayed at this moment to find ourselves on the opposing sides of this bill. We have worked with the author and with the bill sponsors in good faith over the last several months to craft a bill which preserves PACE while strengthening consumer protections and disclosures. However, and we were hopeful that we'd be able to reach a resolution on a path forward by the time of this hearing. However, there are still some disagreements that remain in 4 key areas, and if you will allow me, I'll just outline them really quickly. The first is the bill as currently before you includes a 3-day cooling off period, which would require that the disclosures that we provide to homeowners are given 3 days in advance of them moving forward with the contractual improvement. And that's problematic because the bill also includes a 3-day right of rescission. We don't think both are necessary. The right of rescission allows a homeowner 3 days to cancel the contract if they change their mind or have a problem with the financing terms. And it's also problematic because it undermines the policy intention of PACE, which is to incentivize consumers at the point where they're about to make a purchasing decision on a product that would could improve the energy efficiency or the water efficiency of their home. PACE allows them at that moment to make a purchase that is more energy efficient, more water efficient, when they otherwise would not have made such a purchase. Over 60% of our improvements are financed when a homeowner is making a repair and not solar, for example, which is a discretionary purchase. The second area of disagreement that remains is along the lines of electronic documents. The bill as currently before you allows for an electronic copy of the disclosure to be provided to homeowners, but does not allow for an electronic copy of the right of rescission to be provided to homeowners. We believe that in keeping with Assemblyman DeBobne's other bills related to electronic copies of documents, that it would be in the interest of consumers to be able to receive electronic copy of the right to cancel form. The third area of disagreement that remains is along on the disclosure of subordination and payoff. And this is an area where we have been working with the author and we're working with the bill sponsors. We believe that the amendments that have been made to this particular provision since passage from the Senate Governance and Finance Committee actually removes the notice that the consumers have the right to may have the option of subordination, which was not in keeping with the intent of the amendment made in Senate Governments and Finance. And finally, the bill prevents contractors from making representations about the improvements increasing the value of their property unless backed up with an appraisal, a broker's price opinion, or an estimate derived from an automated valuation model. We agree with that intent. And in fact, we make it very clear as a matter of policy already that contractors shall not state.
Thank you. I've given you way more time. You're the only witness in opposition. These concerns are also addressed in the analysis, so I've got to cut you off at this point, but feel good about the fact you got 4 minutes instead of 2. So thank you. I'd like to, do you want to go ahead to, let's find out, are there anybody else here in opposition? Name, affiliation, please.
Joe Leviach with Renew Financial. We are the program administrator for the California First PACE program, and I just want to thank the author for the intention and strong disclosure bill that we have before us. We wholeheartedly agree with the premise. It's just we need to make sure we get it right. So we hope that we can be very supportive very soon.
Thank you very much. Anyone else in opposition? All right, bringing it back to the dais, Senator Hertzberg.
You brought the Chief Justice's classmate from Harvard Law School with you here, from the class of 1979. And 17 signatures of members of Congress is quite impressive. And I just want you to know that I have a deep prejudice for this author because he represents the same communities that I represent, as does the congressman. That being said, can I give you a hard time on just a couple of questions?
You got it. I'd expect nothing less,
Come on,
my
this will
friend
be
and
fun.
senator.
So I get this whole thing about consumer protection, but my question is this. If somebody gets foreclosed on, right, because of one of these PACE contracts, what's the remedy? What would happen in a normal foreclosure under a power of sale? What's the remedy? Is there, if there's, what happens? I mean, if they're sold out, what happens? Because at the end of the day, it's a fixture attached to the property, a repair attached to the property. What happens? And is there any liability to the consumer?
I will answer that, and I will ask for greater expertise from Stan Wigg from the California Association of Realtors. But I will tell you, the original bill had a subordination clause in it. It's unfortunate that the opposition at that time said that their main concern with the bill was the fact that it addressed their ability to put a super lien that no other non-tax related entity could ever put on a property.
No, hey, look, I got it. I'm shocked.
And the opposition said that we want full disclosure. It's unfortunate that the opposition has moved towards now a different position than we had in those negotiations, and that unfortunately is not in good faith. But what I will say, the super lien situation allows for these companies to be able to go to Wall Street and get capital because they know that if there is a foreclosure, if they don't get their payment through the county assessor every 6 months to pay for this loan, they know that they get first right after that foreclosure and that sale before the mortgage company, before any other debts, before any judgment lien that's on that house.
I couldn't agree with you
And
more.
you could see 4 or 5 of these super liens on the house, and then I guess they'll have to fight amongst themselves because you could do one for water efficiency, you could do one for AstroTurf in your backyard, you could do one for a solar system, and you could do one for new windows and doors. And there's no issue with one company giving 4 of these out for 4 different reasons. So we have now moved this to a disclosure bill. And what we're saying is that consumers, and you can look up and down the state throughout newspapers and local news shows, where you've seen consumers, mostly seniors, where people have gone door to door, misled about this program, and got seniors into situations where their greatest investment, many near retirement age or near paying off their mortgage, has now been compromised. We deeply believe in the environmental protection aspect of this. This is why I believe that the marketplace will expand and more consumers in my community, your community, and our state will have access to this program with greater, I think, confidence in it to get to our goals of renewable energy so the average consumer in our state can think about upgrading, which they would never be able to do with upfront costs. But what we're talking about now is simply a strong disclosure bill and allowing consumers to have greater protections within it.
Yeah, look, I get your point. I don't have any quarrel about it. I'm just trying to understand where the risk lies, right? Who's really bearing the risk?
Well, taxpayers, consumers, who holds the first mortgage, obviously those institutions.
Bearing the risk.
Well, whenever you have a program that's administered by counties, I mean, that's obviously a government entity, you're going to have a situation where if these loans default, you know, and look, no one wants to see foreclosures in our community. And right now, that's not a huge issue because the market's strong. And when you have a situation like we had in 2008 to 2010, if we would have had the same amount of PACE loans with this many liens, because remember, they're taking the equity in a house. That equity is only equity until someone gives you a check for it. That equity can quickly go underwater, and that equity that they put into a super lien can quickly disappear, and now a house that had $150,000, $200,000 in equity can quickly become underwater. And then you have someone that was already locked into a property because they went underwater and they're in a bad housing market that we just saw a few years ago. And this market is still very fragile, and I think Stan will talk of that. But we're going to have a situation now where now you have a super lien for $70,000 on top of the fact that your house might have lost $100,000, $200,000, $300,000 in value in a matter of months. And we saw that just a few years ago.
Madam Chair, can I have 5 seconds just to respond to the question, if you don't mind?
Very briefly.
The question as to what happens in a foreclosure, there have been 0 property tax foreclosures in our program, 0 losses to mortgage lenders. In California, what happens in a foreclosure is the mortgage lender is made whole because there is a PACE loan loss reserve that's run out of the CATFA so that the mortgage banks are placed in the same position they would have been had there not been a PACE assessment on the home. And then just finally, the PACE industry as a whole in California represents 1/10 of 1% of housing units. That's less than 1/100th of 1% of housing units nationwide. So that's the size of the risk.
This is all a little bit of red herring, though. I will say this, Madam Chair, if you'll indulge me for one moment. The fact that there might not be a huge number of houses that have been foreclosed on doesn't take away from the fact that we need stronger consumer protections so that consumers that have, many of them have taken out the loan for good reasons. We all believe in the environmental protection of this program. I've even considered this program for my home. But we must make sure that to preserve this program and put more confidence in it, that consumer protections are not swept under the rug. These are not mutually exclusive provisions. We can have strong consumer protections and allow this program to flourish in our state to provide the opportunity for average homeowners to invest in their home and take a stand that they're able to feel good about for environmental reasons and consumer protection reasons.
All right. No, excuse me. We've got 10 more bills and the bar bill quickly, and we'll consider that your close. I thought it was articulate argument. Senator Hertzberg, briefly.
What I was just trying to get to in this is that I think your points are well taken with respect to the need for informed disclosure. But the truth of the matter is, both with respect to the reserve and with respect to the anti-deficiency legislations in California, how either it's a power of sale, foreclosure works, there's no downside risk. Certainly you could lose your equity in the sense that you've bought all these contracts. The last thing I want to say is a couple of things we'll talk about, because I know you're still taking some other amendments. I do think that this notion, especially with the driver's license thing you're doing, anything else, we should do electronic stuff as part of this. I think it's kind of modernizing government.
Most of the provisions of the bill allow for electronic documents in terms of the contract. And the only thing that we've asked to have in terms of the contract would be the right of rescission for 3 days. We also want to make sure that that's opt-in. Many seniors in our community don't yet feel comfortable with electronic transactions or electronic signature. That's why all the bills, since it was mentioned by the opposition, all the bills I proposed, when it has anything to do with electronic documents or electronic signature, are completely opt-in and allowed to be voided or opted out at any time. So we want to make sure we continue that trend, but I will work with the opposition, and in many ways, we've had very positive dialogue with them, and we'll continue to look at that as it moves to the floor.
Thank you. Is there a motion? Do we have a motion? Motion on the bill. The motion is due pass as amended to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Monning, Wachowski? Aye. Wachowski, aye.
Bill has 4 votes. It's out, but we'll hold the roll open. Thank you all, and keep working on this. I think it's an important consumer protection item. Thank you. All right. Next up, we have Assemblymember Waldron. Is she here? Assemblymember Waldron?
Assemblymember Wood go next.
All right. Very good. Assemblymember Wood has file item 32. File item 32. All right, before we start on this bill, we've had some discussions on amendments that we have requested that you take. I believe it's on page 7, comment 4. The suggested amendment, which will restrict the ability of landlords to prohibit or condition the smoking of medical marijuana, where such conditions or prohibitions effectively deny patient access to medical marijuana. Could you please indicate whether or not you're willing to take that amendment or not?
Not willing to accept that
All
amendment. I'd like to speak to that.
Certainly. Go ahead and make your presentation. Unless I'm further persuaded, I'm going to recommend a no vote then, without that amendment.
Fair enough. Thank you, Madam Chair. 5 years ago, the legislature passed and the governor signed SB 332, which statutorily made it clear that landlords have the authority to prohibit smoking cigarettes or other tobacco products in rental units. That new law aligned with the already existing ban of smoking in the workplace, while also recognizing tobacco smoke may cause death or serious illness. AB 2300 seeks to extend the same authority for landlords to prohibit medical marijuana smoke. Currently, law already prohibits a qualified patient from smoking medical marijuana 1,000 feet away from a school or other youth-related centers, on a school bus, while operating a car or a boat, and in any place where smoking is already prohibited by law. This bill makes it clear that landlords can also prohibit smoking medical marijuana within rental units to protect tenants. Secondhand smoke, regardless of whether it's tobacco or marijuana, is especially problematic in multi-unit apartments and condos because the smoke easily travels through windows, doors, and shared ventilation systems. Neighbors living in multifamily housing can be exposed to toxic or unwanted secondhand smoke. It's a nuisance that tenants should not have to live with. By now, we're all aware of how dangerous secondhand tobacco smoke can be, but the awareness for secondhand marijuana smoke is not the same. A recent study by UC San Francisco researcher Professor Matthew Springer, who's a professor of cardiology at UCSF, states that smoke from marijuana can damage your heart and blood vessels as much as secondhand cigarette smoke. This study highlights another reason why we should make it clear in law that a landlord has the ability to prohibit medical marijuana smoke. This study has now been accepted for publication by the Journal of the American Heart Association. AB 2300 does not infringe upon the Compassionate Youth Act, Proposition 215. Prop 215 clearly states that it is intended to, quote, to ensure that seriously ill Californians have the right to obtain and use marijuana for medical purposes. But Prop 215 is not specifically mentioned the right to smoke marijuana. AB 2300 does not prohibit other consumption forms of medical marijuana. Edibles, oils, vaping, lozenges, inhalers, many other things. From our conversations, I've done my best to resolve the chair's concerns. I'm ready to take the amendments.
I appreciate the work that you've done, and I appreciate your efforts.
No, I understand. No, I appreciate it.
Please go ahead.
I'm ready to take the amendments that carve out an exemption for terminally ill patients, as we discussed, to allow them to vape their medical cannabis. Americans for Safe Access, the leading medical cannabis rights organization in California, has said that vaping is, quote, equal or better route of administration compared to smoking. I've shared this with committee staff as well. I also want to point out that Americans for Safe Access and CalNormal are neutral to AB 2300, and if, with accepting the amendment for vaping, that would eliminate all opposition to the bill. This bill passed 77-0 in the Assembly, 10-0 in our Judiciary Committee. That being said, I cannot accept the committee's proposed amendments outlined in the analysis. These amendments, in my opinion, would create a massive loophole in my bill and make the status quo even worse. It would allow any tenant to make the claim that their access to medical marijuana is prohibited. We're going to have endless lawsuits from this vague clause. Frankly, the status quo would be better for landlords given their track record in court. Prop 215 expressly allows seriously ill Californians to have the right to obtain and use medical marijuana for medical purposes. It does not specifically authorize smoking for medical purposes. AB 2300 does not prohibit other forms of medical cannabis consumption. Like I said, vaping, inhalers, sublingual, edibles. There are multiple ways of getting this. And if we add taking vaping, that has already been said to be a more effective, potentially more effective route. Finally, what about the people next door? The neighbors in multifamily apartments, don't the mother, the young kids deserve the right to have a smoke-free home too? With me is Shonda Peckian from the California Apartment Association, and I respectfully ask for your aye vote.
Thank you. Go ahead. We'll get to the gravamen of this shortly, but thank you. 2 minutes, sir.
Madam Chair and members, Shanta Pekin on behalf of the California Apartment Association. We are in support. As stated, smoking is a major source of conflict between tenants in rental housing. Smoke easily goes from one unit to the next through ventilation, through windows. And one of the most complaints we get from landlords is that tenants are complaining, particularly those tenants that have children and have families that don't want their kids to be exposed to harmful secondhand marijuana smoke. As the analysis pointed out, UC recently did a study which concluded that secondhand smoke from marijuana is equally as harmful as tobacco. In light of the many alternatives available, we don't believe it's appropriate to prioritize the health of one family over the health of another next door. So we believe this is a reasonable approach and ask for your aye vote.
Thank you very much. Other witnesses in support?
Madam Chair, members of the committee, Jennifer Speck on behalf of the California Association of Realtors, also in support of the bill for reasons previously stated.
Thank you very much. Others in support?
Betsy Armstrong with the County Health Executives Association, representing local health departments in support.
Thank you.
Amber King with the Association of California Healthcare Districts in support.
Thank you. Any other witnesses in support? Are there any witnesses in opposition? All right, seeing and hearing none, let's bring it back to the committee. I appreciate your concerns here. I don't think there's any dispute. The issue, as I see it, is not one of allowing people to smoke marijuana because they have medical needs or because they just want to smoke marijuana. It's clearly there is a secondhand smoke issue. No doubt, the smell of marijuana is rather discernible, quite distinctive, and to some people rather obnoxious. To some people, it's wonderful. But that being said, the issue, as I see it, is there is a place that it's been determined for the smoking of medical marijuana for terminally ill people. And what we had been talking about is carving out a very limited exemption for terminally ill people who need to get the relief that is provided by medical marijuana, who literally cannot go elsewhere. They are generally bedridden. They are in the last throes of their lives and cannot leave their apartments or cannot leave their homes or whatever, but for whom this is truly a medicinal treatment to basically address the pain associated with whatever is their underlying illness. That's as I believe, that's what the amendment simply asks for. Now, I don't think there's any evidence or scientific evidence at this point in time as to whether ingesting marijuana is better than vaping it, or I know that there is some indication that for those with certain terminal illnesses, smoking marijuana is helpful. To make this distinction, I just don't see any evidence for it. And I think it's probably something very narrowly crafted. There are very few instances that I can think of where we're going to see people who are in these circumstances smoking marijuana because they're dying in an apartment building next to people who would rather not have to deal with that. I'm sure, again, this isn't people who are smoking recreationally. These aren't people who perhaps have had some health issue or have glaucoma and could go elsewhere. This is people who literally cannot get out of their homes because marijuana, the smoking of this marijuana, is what is aiding them in the last throes of their lives because of the pain and suffering they're having based upon that underlying injury. If you could respond to that, I just...
Yeah, I'd be happy to. I mean, yesterday we spoke. I completely agree with your desire to protect terminally ill people. Prop 215 didn't give people the right to smoke marijuana. It gave them the right to consume marijuana. You can consume marijuana in many, many ways. And vaping, as I mentioned earlier, the advocates for patient rights have said that vaping, through vaping devices, which are like smoking, but without smoke, is actually as good or better method of transmission of marijuana. And so if we're trying to alleviate the discomfort and conditions for these patients, the vaping exemption accomplishes that. I believe the additional language there creates a huge loophole where everybody will complain that they can't do anything but smoke marijuana. And that people consuming their medication shouldn't endanger other people's lives. And that's really what I'm after here.
And I don't disagree with you. The very narrow exemption has to do with people who are literally dying and who are bedridden, who cannot volitionally remove themselves from their homes because they don't have the energy or the strength. I'm not talking about someone who's got a headache. I'm talking about people who are truly using marijuana as a way just to sort of aid as they address and, if you will, leave this world because of a terminal illness.
Madam Chair, we offered some language yesterday which was not taken up, and I'd like to read it with your permission.
Sure.
There shall be an exemption for patients who have a terminal disease to allow the vaping of medical marijuana if the patient's primary care physician and specialty care physician provide documentation that the patient cannot consume marijuana in other forms. The primary care physician and specialty care physician shall not be a physician that recommends the use of medical marijuana. Terminal disease means an incurable, irreversible disease that has been medically confirmed and will within reasonable medical judgment, result in death with 6 months. That, I believe...
Well, so here's the problem with that. A primary care or specialty care physician cannot prescribe marijuana the way the convoluted laws exist today. It can only be, can't be prescribed. There has to be a recommendation from a physician for the use of marijuana. I mean, there are some absolutely stupid rules out there which create an impediment to our ability to address this problem constructively and logically. And so we have all of these obstacles created because we have all these rules associated with it. And so that's why I think we were unable to accept that suggestion.
Madam Chair.
Please, and then I appreciate this, you know, if it weren't 4:30, if we still didn't have 10 bills to do, we could continue this conversation. I really appreciate what you're trying to accomplish. I'm trying to work with you to get there, but I'm just finding this is, that for some reason we're stuck. And it's frustrating, I'm sure, to you, and it is to me, because I think we really, if somebody has a suggestion up here, that would be helpful. But let's let the Assemblyman respond, and if you want to.
I'm fully aware. I'm fully aware that physicians cannot prescribe medical marijuana. acutely aware of that. And so all we're asking for is that the physician or the primary care physician or the attending physician for terminally ill patients would document that this person is terminally ill, that they may benefit from that. We're not asking for a prescription. We know that can't happen. And what I don't want to see is the doc in the box who oftentimes prescribes these or makes these recommendations be the one to make that determination. So if we're both trying to get to the same place to make sure that terminally ill patients are cared for, and if a physician feels that that's adequate and they can justify to provide some documentation to a landlord, then that's what we're after. Smoking isn't it. And if people are concerned about costs, I mean, dispensaries out there have compassionate use programs. They do their best to take care of patients who are in exactly the same situation you're talking about. But I'm offering an alternative in the vaping that allows for people to get as good or better pain relief than smoking without damaging their neighbors or infringing upon their neighbors' rights. And so I'm not sure how we get around this, because I think we're on the same thing, and other than bringing vaping devices in here, which I think might have created all sorts of other issues, to demonstrate that, I'm not really sure where to go, Madam Chair.
I don't know if there of any scientific evidence that concludes that vaping is more effective for people with terminal illness in addressing their addressing their pain and suffering and what have you. But Senator Morlock, did you have a thought?
Well, I have two thoughts, Madam Chair. The first is to make a motion to move the bill without committee amendments, or the second would be to make the motion with the author's proposed amendment based on which he would prefer.
Well, Senator Wojtkowski.
I guess I shared the chair's concern about not having the data on the, it may be true. This is the first time I've ever heard that Prop 215 was not about smoking marijuana, it was about consuming it. I mean, it may, in fact, be the way the text is. I think most people at the end of life, it's just tough sitting up here today to say, I've got to run to the doctor and then run to my landlord to make sure that I get the hall pass before, as I'm having this palliative care at the end of life. I mean, and it may be offensive to another tenant, but it's allowed now, I guess.
So let's break the logjam. I respectfully will urge a no vote if that is the way we work on this. We're very close. I'd like to get to a resolution. I share Senator Wojtkowski's concern. If you're dying to have to do all this is, I think, just unrealistic. I wish there were some, if you had documentation that vaping is the, works, but we're just hearing anecdotally, and we're close, but I just cannot support this without some kind of a specific criteria that gives that exemption, just on behalf of those who are dying. Yes, sir.
Well, first of all, thank you, and I appreciate the indulgence of the committee and the time that's involved. And I think you hit on an issue that is critical and a challenge for anybody related to medical marijuana in this country. There is a huge lack of data on the medical effectiveness, period. We can't get federal government's control over the issue, makes it difficult for universities to apply for funding to do the kind of research that you're talking about. So yes, we do not have the data that you seek. It doesn't exist. We do have, as we do with most of the medical marijuana community, anecdotal evidence. I think if this were an issue for patient advocates, I think you would see a stream of people here objecting to this, but they are neutral on the bill. They are not objecting. And the two groups that did opposed because we did not have an exemption for vaping, which we are accepting. So there really is no opposition to the bill at this point. And so
I understand, but that, although that's helpful.
Well, I mean,
yes. I am the chair, as Mr. Hertzberg would say.
There is no written I'm gathering that.
Assembly member, I just, I appreciate what you're doing. I just can't, without that exemption, I'm trying hard to get there. I appreciate the work you've done, but and I'll let my colleagues do as their conscience provides. I just, on behalf of the many people that really are, that for whatever reason find that this is helpful to them during the very last vestiges of their lives, I just cannot agree to support this bill without that amendment. So with that, if you'd like to close, that would be...
I appreciate that. I'd ask you to consider moving the bill, working with me to, and not bringing it up on the floor until we can come to a resolution.
If you'd make that commitment, then I will agree to help you do that. We're close. My heart goes out to too many people I've
Mine
known
too.
who really have been in trouble. So with that agreement, we will go ahead and just let the bill, make a motion, if someone would make a motion, the bill as presented to the committee. And we'll keep working. I'd like to try to do that. Very good.
Thank you, Madam Chair.
All right. With that, the motion is due pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno? Monning? Wachowski?
Aye.
Wachowski, aye.
Thank you.
Thank you.
Next up,